Hello, Big Mocker Sir. My name is Patrinia Johnson. I chose the movie Silver Linings Playbook and chose actor Robert De Niro since he had won an Oscar. Here's the research I found. The first link I went to is the actor's International Movie Database biography page. While reading his biography, it was mentioned that the actor had been caught up in a prostitution scandal in Paris in 1998. So I went to the actor's wiki page and recalled he was in a film called Taxi Driver in 1976, which he was nominated for the Oscar for Best Actor, and the film was nominated for Best Picture. Remembering that Jodie Foster played a prostitute in the movie and was also nominated for an Oscar for Best Actress, so I went to the movie's wiki page, where it was mentioned that John Hinckley Jr. became fixated with Jodie after this movie. He mimicked Robert De Niro's mohawk from the movie and attempted to assassinate President Ronald Reagan to gain Jodie's attention. He was later found not guilty by reason of insanity. This led me to my second link. This article is titled John Hinckley Trial and Its Effect on the Insanity Defense. This article talks about the insanity defense and the backlash after his verdict. It describes that 80% of the reforms on using the insanity defense happened shortly after his trial. It mentions some states limiting the use of expert witnesses and a few states getting rid of the insanity defense altogether. From here, I decided to use my college's library research center and do a search on insanity defense abolished. This led me to my third link. This article is titled U.S. Supreme Court Denies Review of Idaho's Abolition of Insanity Defense, 3 Justices Dissent. It is mentioned that Idaho abolished the insanity defense in 1982, and how an inmate named John Joseph Delling, who was sentenced to 2 consecutive life sentences, wanted the Supreme Court to overturn his conviction. He argued that the abolition of the insanity defense violated his rights under the 6th and 8th Amendments. The Idaho Supreme Court upheld his conviction, and the U.S. Supreme Court declined to review his case. But there was a shock. On November 26, 2012, Justices Breyer, Ginsburg, and Sotomayor noted the absurd result reached under Idaho law that permitted a defendant to argue that because of mental illness he lacked the requisite intent or mens rea to commit the act, but not defend on the basis that he was operating under a delusion when he committed the act. This led me to my fourth link. Well, actually, this led me to wonder about the impact of dissenting opinions, which led me to my fourth link. This article is titled Dissenting from the Bench. This link talks about how a dissent from a justice allows them to talk publicly about their disagreement with the other justice's decisions. It also talks about how a justice dissenting can bring media attention about a law that may have otherwise not been known about. And this led me to my fifth link. The article is titled Landmark Cases of the U.S. Supreme Court. The link talks about the famous case of Miranda versus Arizona, where it was decided that law enforcement must read suspects their rights. The case was a 5-4 decision, and Justice Harlan, along with Justices Stewart and White, explained that this new ruling would decrease the number of confessions. They explained that with warning the suspect that he has a right to remain silent and having an attorney present can effectively shut down the interrogation. In their dissenting opinion, they believe if a police officer is going to lie, they will lie about the Miranda warnings also. So, there you have it, Big Mocker Sir. Those are my 5 research links. Thank you.